So as we were doing earlier this month, we had a board of trustees meeting for the foundation, and we did sort of an orientation meeting covering what the foundation is and does, particularly focused on our new directors. But a piece of that was the question of what do our directors do? What do our trustees do? What is their legal obligation? What are their duties? And that question applies to the directors of church, the board, the leadership group within each church setting as well. So David had asked me to share some of those thoughts with you all today, so that we can hopefully all kind of get a little bit better understanding of it. So if your church is incorporated, and virtually all of our churches in our conference are, it is led by a board of directors. That is the group by statute which has the authority and the duty to run the corporation, the church corporation. It goes by other names too, a board of trustees. In some churches, it's called the church council. And in the church community, of course, there's all kinds of very different and sometimes very creative names that churches use to identify their leadership group. But by statute for the church corporation, that group is the board of directors. And it doesn't matter what name you give it in your bylaws or refer to it. And the church board of directors exercises all corporate powers of the church. And it has authority to deal with all the management of the corporate affairs of the church, and that is by statute. So the people who serve on the board of directors are, by virtue of their position, fiduciaries. And a fiduciary is a person who serves in a position of trust to care for the property and assets of others. And in the present context, we're talking about the property and assets of the church. And David has given you several different definitions of fiduciary, but they all are of this theme. This is what it really means. And referring to, David had cited from Black's Law Dictionary, one of my favorite books. I have a copy right here, but it does say that the fiduciary standards, the fiduciary duty, is the highest standard of duty implied by law. So it is a standard that is held to trustees and guardians and anybody who is in a legal position to care for the property and assets of others. So you hear the term fiduciary duty, it gets bandied about a lot, but folks sometimes really don't know what it means and how you break it down. So it really breaks down into three categories of duty: the duty of good faith, the duty of care, and the duty of loyalty. So let's talk about the duty of good faith. Duty of good faith is kind of like it sounds, at its basic, it is honesty, fair dealing, and candor. If you remember nothing else, remember that. Those are extremely important things for management of the affairs of your church and being a fiduciary. But it means also observing local, state, and national laws and regulations that apply to the institution. It means acting for the benefit of the entity, not yourself, the entity, and being true to the mission of the entity. Now, board members can exercise their own reasoned judgment about how the institution can best achieve its mission. That's one of the things that they do, but they cannot act in a manner that's inconsistent or contrary to that mission. So in general, board members, directors need to act with a conscious regard for their responsibilities as fiduciaries. And everything they do, they have to keep this in the back of their minds and their head. The duty of good faith, really the duty to put the mission of the organization first, follow rules and laws, used to be called the duty of obedience. You will see that in literature about fiduciary duties, but that's subsumed generally into the duty of good faith. Now, the second duty we talked about is the duty of care. The duty of care describes the level of competence expected of a director. The care that, and it is basically the care that an ordinary, prudent person in like position would exercise under similar circumstance, and in a manner the director reasonably believes to be in the best interest of the corporation. Now that is, you see the numbers there. That's a statutory site. That comes right out of our Hawaii revised statutes. Now, individuals are not presumed to be experts. In fact, the statutory definition, here's one of my other favorite books, the Hawaii revised statutes, reads like poetry to me. The statutory definition really says the only qualifications of a director are that they are individuals. And that's all it says. It goes on to say that the article and bylaws may prescribe other qualifications, but it's very open. But nonetheless, these duties will apply to all individuals in whatever capacity they serve and with whatever experience. So coming back to the fact that the law does not presume that the individual is an expert, but if they do have expertise, they have to use it. So if you have lawyers or doctors or accountants on your board and the question bears on a question of law or accounting or medicine or whatever it might be, and somebody has experience in that area, they're expected to draw upon that experience for the benefit of the organization, for the benefit of your church. So an ordinarily prudent person, well, what is prudence? Essentially, it boils down to common sense. You as a director need to be acting with common sense. And in terms of the circumstances, that what is similar circumstances? Unfortunately, there's no bright line test. There's nothing we can open a book and say, oh yes, I am, I'm not, I should, I shouldn't. It comes down to the activity and the circumstances. So our directors need to look at each situation differently and exercise some common sense. So the duty of care, well, what does it mean? So, I mean, how do you get to it? How do you crack down on it? Well, one, be reasonably informed. Directors should make efforts to find out what's going on and learn about their organization, about their industry, about the situation. And then participate in decisions. You're not doing your duty if you're not involved, if you're not an active participant. So don't be a wallflower and just sit there, get involved in the discussions. And then exercise independent judgment. Don't let yourself be influenced by outside sources or whatever. You do what you think is best for the organization in good faith. And as I just said, so do so in good faith. And you'll see that the good faith aspect pervades really all of the fiduciary duties. So what do you do to make sure you're following the duty of care? Well, you need to have meetings if you're on the board of directors, and make sure that the board does regularly meet. So there's an opportunity to monitor things that are going on and make decisions and keep informed. And then obviously attend the meetings and participate in the meetings as I discussed before. Again, you need to obtain adequate information. If you're not sure about something, it's your duty to go out and find out that you have enough information to make an informed judgment about the situation. And again, exercise independent judgment. You're there because of you and who you are, and you have a vote, and you need to use that wisely. You may, however, rely upon trustworthy sources for that information and advice. Obviously, as I said, you have all different levels of experiences on boards of directors, especially in church boards of directors. So directors, it is reasonable and acceptable for directors to rely upon the opinions and reports and the statements, including the financial statements and other financial data, if they are prepared and presented by reliable and competent officers, employees, professional advisors, or committees of the board. So you can get support. You can find other sources of information. Your duty as a director is to determine if that information is reliable and put together by competent people. So let's turn to the third fiduciary duty, the duty of loyalty. That is, as it sounds, a duty to be faithful to the institution. Here's a little on the side, there's a picture of my dog. He's very faithful. He's good at the duty of loyalty. He follows me around everywhere. Although he's very influenced by food and other things, so I don't know if he would be good on a board of directors. But you need to put the institution first in decision making. And of particular importance under the heading of duty of loyalty is avoiding conflicts of interest. You also, similar to conflicts, you must not or cannot usurp corporate opportunities for personal gain. And finally, you need to protect the confidentiality of the organization. As a director, you will be privy to many confidential documents and communications and situations, for example, employment contracts and personnel reviews and financial information, possibly litigation discussions and materials, things that it is not appropriate to be known outside of the organization. So as a director, you need to keep those things confidential. The Hawaii Conference actually back in 1979 adopted a code of ethics for its trustees just to help provide a little framework about some things that are expected of the trustees that would allow them to discharge their fiduciary duties properly. And that is our trustees must be active in the management of our organization. It must be diligent and skillful, must consult with other trustees, must be confidential in certain matters, must seek legal and professional advice as needed, must be guided by good faith and fair play, be alert to all danger signals and prevent wrongdoing, must guard against undue influence, and must disclose pertinent information to beneficial interests. And finally, must not delegate authority. By the way, that last, the delegation, should be noted, that's not to be confused with relying and seeking guidance from reliable sources of information. But the final authority does lie with the board of directors. The whole concept of good governance is wrapped up in the fiduciary duties and making sure you discharge them well. And some things that are good for good governance. This is a little chart that I liked. It came from the Council of Nonprofits website, but this sort of gives you a picture of what good governance is. And in good governance, there's efficiency, there's accountability, there's transparency, there's responsiveness. It's consensus-oriented and participatory and inclusive, and most importantly, it's following the rule of law. So I want to talk for a minute about conflicts of interest. So a conflict of interest, a conflict or a duality of interest concerns a board of directors who has a barrier that prevents them from being impartial and loyal to the nonprofit organization. And conflicts can arise from personal, professional, or volunteer positions or relationships. In particular, the law is concerned about financial conflicts. Directors should not be using their position to enrich themselves, their families, or their friends. A financial interest is a compensation arrangement or potential arrangement with the institution or the entity doing business with the corporation, or an ownership or investment or potential ownership investment in the entity transacting business with the institution. And it could be direct, it could be your own individual ownership in another entity, or indirect, if a family, a business, an investment, could give rise to the conflict. So for example, if you are a contractor and you are a member of a church and you are proposing, and also a director of the church, and you're proposing to offer your contracting services to the church, you have a conflict in bringing that forward, because you may be paid, you may be hired to do the work for the church, but you are also a director. So So what do you do in that scenario? Or what does the church do in that scenario? Well, first, directors have a duty to disclose the existence of the conflict of interest to the board. So the first thing you would do is say, hey, wait, this is my company that's bidding on the work for the church, and I own it, or I'm a partner in it, or whatever the situation is. So you need to know that, board, up front. That duty to disclose applies to the individual with the conflict or those who know of the conflict. So if that individual does not speak up, the other directors on the board who do know of the conflict have a duty to speak up and inform the rest of the group that there is a conflict. And it's a continuing conflict. You're not excused if you simply make the disclosure in January and assume it's good for the next 2 years. You need to bring it up every time it comes up in discussions before the board so that those who have forgotten can be reminded and the proper procedures are followed for dealing with the conflict. Now, if you have a conflict, it doesn't preclude the church board, for example, going back to our contractor scenario, from choosing that contractor and entering into a contract with that director's company. But the evaluation of whether or not that's prudent and in the best interest of the church corporation must be done by the disinterested directors. So those are people who don't have any conflicts, right? And the person with the conflict should not participate in deliberations or voting. Now that is statutorily, if the person should participate and vote, it doesn't necessarily make the decision by the disinterested directors defective, so long as a majority of the disinterested directors have approved the matter. But as a matter of practice and good governance, it is best for the conflicted director to excuse themselves and not participate in either the deliberations or be there for the voting. And the reason is you don't want the appearance of undue influence on the rest of the directors, on the disinterested directors as they're making their decision. So those are important things to keep in mind. Every church should have a conflict of interest policy. It should have an actual written statement that it gives to its directors and those who are in positions of leadership, reminding them of the duty not to follow, or the duties with respect to conflicts of interest. And churches are, as many of you know, charitable organizations pursuant to the Internal Revenue Code, Section 501c3. And Section 501c3 organizations are required by the IRS to have a written conflict policy. So the Hawaii Conference Foundation has a policy. The Hawaii Conference of the United Church of Christ also has its own policy. And every year our directors are asked to sign that, to acknowledge that they read it and they understand it. So I do encourage your churches to adopt one if you don't have one, and to refresh everybody's memory about it on an annual basis. So some folks, hearing sort of the legal side of things may be a little intimidated if you're just a volunteer, and especially if you don't have any background in the law or a business or anything. You think, golly, why should I get involved? It sounds scary. There's a lot to think about, and potential liability, et cetera, et cetera. Well, I mean, how can I be assured that it's okay to participate? Well, when a corporation's action has proven unwise or unsuccessful, a director will be protected from liability if the director acted in good faith in a manner that director reasonably believes to be in the best interest of the corporation, and with the care that a reasonably prudent person would use. The law does provide some protection for our volunteers. Now, you might say, this director who's concerned might say, well, gee, those are all really subjective. What if my judgment is different from somebody else's? Or worse, my judgment is different from the jury or judge who's sitting on this case. Well, there are still other protections. Now, directors are generally protected by statute from personal liability arising out of the debts and liabilities of the corporation. In fact, one of the main reasons to incorporate is to ensure that those who are doing the work of the church, the work of the organization, are doing it under the umbrella of a corporation, which can shield them from liability. The corporation has by statute the right to indemnify its directors and officers from claims from their acts as directors and officers. So if they get sued individually because of something they did as a director, the corporation can step in and defend them and indemnify them from any judgment or liabilities that arise. And specifically under our statute, just to make sure that we don't lose good volunteers because they're afraid of potential liability, there's a provision that says a volunteer director, that is, a director who is not being paid for their service, will be protected from liability unless the conduct was grossly negligent. So really, really bad. You know, they directed, they knew there was a conflict and they directed funds to go to them, or they just were just beyond the pale by any reasonable judgment with respect to their conduct. So if they tried, they're aware of their duties, they gave it their best efforts, they will be shielded from liability for the act. Now, I want to, well, first I want to say that here are my contact information if you have any questions, as well as Corinne Murashige, who is our controller, who, as many of you know, deals very capably with all of our complicated financial situations, and Maureen Arata, my assistant, who keeps me out of trouble and online, and so please do feel free to reach out to any or all of us with respect to concerns you may have. But in particular, if you have concerns about this talk, fiduciary duties, etc., check in with me. I'm happy to chat more about it with you. I do also want to encourage you or your church to establish a relationship with an attorney to help you through this type of training on a regular basis, reviewing contracts, reviewing issues and problems when they arise, or as they really before they become a problem. You want to make sure that you do the legwork up front so that you're not reacting to a bad problem down the line. But that said, I'm no longer actively practicing law since I'm now the executive director of the Hawaii Conference Foundation. So I'm just imparting this advice to you as somebody with a little experience and background, but not as the attorney for your church. And in regard to me picking up a new shingle and hanging up my old law degree, I share with you this little comic that rings true with me, where the dad's saying to the son, "Certainly a law degree is worthwhile endeavor, son, but you need something to fall back on. Now practice your banjo." So I thought that was funny. Anyway, so that's my little spiel about fiduciary duties. Tried to keep it pretty simple. You could obviously spend a lot of time on each of the elements and drill down into cases and circumstances and scenarios and all of that. But that probably is a little out of the context for today. But at this point, I will maybe open it up for questions. Actually, before I take questions, I want to lift up we had a question this morning about directors and officers insurance. This is something I think David Takagi will talk about this weekend, but every church should have directors and officers insurance. That is insurance that protects the individual directors and officers from liability, from being sued, or from liability arising out of being sued because of their conduct as directors and officers of the church. As I mentioned earlier, the church corporation can indemnify, and usually does indemnify, directors and officers under that scenario. And the insurance company actually provides the money to hire the lawyers and the money to pay out a judgment if there is one. So it's a really important piece of your general insurance package. It is something that the insurance board does cover and does provide as part of the insurance package that churches get. So do make sure that you have that. So at this point, I'll stop there and see if there are any questions from the group.
Hi, Andy. Pastor Olaf here, although it says Samuel Whitney. Never mind that. He was a great missionary.
I like that.
We pay homage. You've been talking about volunteer board of director status, and the question that always comes up is the pastor considered a volunteer because actually paid to be there? And most bylaws in churches say ex officio on all boards and committees.
Yeah, Olaf, I think I just lost your connection there, but I think I got the question. I mean, a pastor is a paid employee of the church and would probably not be considered a volunteer director. And to the extent that the pastor is a non-voting member of the board, really the way the law chalks up, a non-voting director is really not a real director. And doesn't necessarily that all of those fiduciary duties don't necessarily always apply, but the pastor is in a position of trust and is in a position of authority, and so there will be a fairly high set of standards applied to that pastor's execution of their duties. Now, a pastor can be fired if their judgment about the pastor's judgment about how to proceed in one way or the other disagrees with the board's judgment. Could potentially have some degree of liability that individual directors are exempted from, because the individual directors are all just simple volunteers. So there might be a little more exposure to the pastor with regard to the execution of the pastor's duties under the law.
Yeah, I'll just share with you, if I might, that Judge Fujisaki, Superior Court of California, the one who did the O.J. Simpson civil trial, laid that on me in a court case from our church. He said, "Are you not an officer of the church? And are you not the chief paid officer of the church? Should you not know these things?"
Mm-hmm. Yeah. Yeah, well, and as an officer, the fiduciary duties do apply to officers, but you're right that the double-edged sword for the pastors is they're not volunteer officers, they're professionals, so might be held to a higher standard.
Do you have a copy that we can use? I mean, the conflict of interest statement is somewhere online, I'm sure, right? Because that's something that's not in our policies and procedures at the moment and needs to be, sounds like.
Yeah, we can find you a template. There are many out there to use, and yeah, we can help you find something like that.
Thank you. And I guess I should ask, the associations need to sign off on this too, because they're under the conference 501c3, yeah?
Well, yes. So, and that's a great point, actually. Thank you for bringing it up. I mean, all the associations and our churches all fall under a blanket recognition letter from the IRS in terms of the 501c3, but they're all individual corporations. And so each of them have their own boards, and each of the boards of the association and all of the various churches have those duties vis-a-vis their own organization. Now, and that potentially gives rise to conflict situations, which I think in our polity we have to be a little more astute about, or aware of, because by virtue of our positions, we often sit on multiple boards. For example, David it sits on the board of trustees of the foundation. So there may be circumstances where he needs to recuse himself because the decision before the board is directly beneficial to the conference or what have you, and that happens with respect to our associations as well and churches as well. But the key is to disclose and make sure that people understand that. And once that's out there, it's much easier to grapple with. And it's certainly easier to deal with up front than having to go back and realize after the fact that somebody may have had a conflict and it wasn't disclosed. And now what do we do, et cetera, et cetera.
So I'm sorry I'm stealing everybody's air time here, but if I'm taking minutes for the Kauai Association as a secretary and it's not a motion, yet there's a disclosure, that should be then recorded for legal purposes. Is that right? Is that what I'm hearing?
I would. I think you want a record that a disclosure was made about a potential conflict, so that later on, if a church member, let's say, or a member of the association comes forward and say, "Hey, this was never raised, was never addressed," you can say, "Yes, it was. Look, it was disclosed. The person with the disclosure excused themselves. The disinterested directors discussed, made the decision, and then the person with the conflict returned after that." That's the kind of thing I think would be worthwhile to make note of.
I had a question about a slide that was early on in the presentation, and it said something about good faith and obedience. And it was unclear to me what obedience means in this context that we're talking about.
Obedience is the duty. It's under the heading of the duty, the larger heading of the duty of good faith. And there used to be, sometimes you hear people, and it was more of older parlance, talking about the duty of obedience, which really is the duty, obedience to the organization. So about acting for the benefit and being true to the mission of the organization, and being true to to observe all applicable laws applying to the organization. So that's the duty of obedience generally. I guess it's a little bit harder edged term than the duty of good faith, but
Thank you.
And on that note, can I ask what your dog's name is?
you sure can. His name is Hachi, which is
Hachi.
Japanese for a. He came with that name from the pound. He was a rescue dog. So I think somebody thought he looked like the Akita that was in that movie with Richard Gere about the dog who goes to the train station every day to wait for his master to come home, and the master never comes home. It's a very sad movie, but the ultimate sign of loyalty, I guess, is the dog for years would go back to the train station. I don't know if y'all saw that, but I guess that's more than you bargained for. His name is
good. Yeah, that's good. Good. Thank you. Well, since you mentioned having a lawyer for the church, is you talking about like an annual retainer, or is just you have a relationship with the lawyer and when the time comes you go and talk, or how does that work?
Well, the most important thing is to have a relationship, so that you there's no hesitancy to pick up the phone and call them up and ask a question. But you may want to consider, and it's up to the lawyer and you to determine what the best arrangement for that is. If an annual retainer can be worked out so that you would be less hesitant to call that lawyer, great. That's one way to go about it. But I think, we always, in the church world, we struggle with money sometimes, and unfortunately, the budget for hiring legal counsel often gets set aside, and that's generally a mistake. There should be some funds every year set aside so that you will consult an attorney when you need it, to look at critical contracts or to help you with hard bylaws issues, or as questions come up all the time, and it's really good to be able to have somebody to give you what the legal perspective is on whatever that question is.
Yeah, we're kind of doing an insurance review right now. I'm sorry, I'm not sure who's there. If I can just ask. So when we're considering our insurance packages and we're looking at the board of directors liabilities, we should probably be thinking more in terms of the lawyer's fees, or how to put that nicely.
Well, yeah, having insurance is incredibly important. You need to make sure that you have that in place. If you have a problem later on that is covered by the insurance company will generally hire the lawyers. But there's a lot of things, your insurance doesn't cover a review of your bylaws, for example, or a difficult question about a conflict, or you're doing a contract with somebody and you're just not sure about it. None of that is covered by insurance. So you need, and generally will need to, hire a lawyer to help you with that, just as you would hire an accountant to do your audit and help you with your well, if you're filing 990s or other type general excise tax returns and that sort of thing, it's an important sort of professional fee among the bundle of professional fees that churches should budget for every year. Yeah, and that said, I'm out of the professional fee business, and my even don't get any referral from any law firm at all. So I'm saying this purely as you know, best interest advice to our churches.
Andy, this is Laurie Uishi. I was wondering
Hi,
if
Laurie.
we are looking at establishing a relationship with a lawyer. What type of lawyer would be a corporate lawyer?
A corporate lawyer is good. They will be the best, the strongest on bylaws, policy type issues, tax issues. But you know, somebody in a more general practice or broader practice is also fine. I mean, my own background as an attorney and as the conference attorney for many years, I'm really a business and real estate lawyer, but many times I would function as a general counsel, and where I realized the problem was outside of my expertise, I would reach out to a colleague of mine who does have that expertise and help the conference get that question answered. So you want somebody, a business lawyer, a corporate lawyer is a great person to have in that role. If somebody who's good at, they tend to be very good at contracts and that sort of thing. And if it turns into an employment matter or a litigation matter or something along those lines, they can find you somebody else to help out in the process. But it's establishing a relationship with a competent attorney is the most important thing.
So we kind of have a relationship with a lawyer who handles charitable organizations, and that's been really super helpful.
Great.
It does not work for charity, though.
Wait, I'm sorry, I missed that. It does not work for what?
You still have to pay them. It does not work as a
Oh.
charity himself. So it was a bad joke.
Yeah,
Sorry.
well, I think you know, that's life. I mean, sometimes you'll find somebody who's generous, or they'll discount their fee, or they'll even do it pro bono. You know, lawyers, in fact, are required to do so many hours of pro bono service every year as part of our ethical obligations to the bar. But I think it's a mistake from a fiduciary standpoint to limit yourself only to legal lawyers who do pro bono service. At some point, you're going to have to anticipate that you're going to have to pay people for their time. And I think from the, you know, that ensures you're in the pipeline. You're not discounted in terms of when the lawyer, how much time the lawyer gives you. You want them to treat you like their very best client, because you want the very best service from them.
I suppose if you have a lawyer in your congregation, you should avoid using that person because of conflict of interest, would you say?
Well, again, it depends. You're going to have to, certainly avoiding using that person solves any potential, any perception of conflict. But if the lawyer is in your congregation, they're not necessarily on your board, so they're not party to the decision to engage that person. So that's okay. And so long as the lawyer in the judgment of the board is you know, providing market rate services. I mean, they're competitive with anybody else in their field for what they're going to provide to the church. That's okay. In fact, it's often the lawyers in the congregation who are most willing to provide a little bit of pro bono help on top of that. But you shouldn't put that on them as an expectation.
Andy, you said on the board of directors with the pension board, is this a point, are they ready to talk publicly about what they're looking to do in terms of lawyer accessibility for local congregations?
Mm-hmm. Yeah, actually, it's not the pension board. I'm on the board of directors of the insurance board.
Insurance board,
but yes,
thank you.
I know there's so many meetings with different boards, but no, yes, I can talk about that a bit. The insurance board is working out a program where for everybody in the program, all the insured churches, there'll be a legal hotline or a legal call line that they will establish which will be fielded by a lawyer, initially by a lawyer who is well-versed in church affairs and as well as our denomination. And initially as a screen, there'll be maybe a little discussion. That lawyer may be able to answer questions that you have right there. But then if it needs to be something that a local attorney has to handle, because lawyers are licensed by jurisdiction, he would refer you to your local conference attorney, who then could provide that legal assistance or help or find somebody to provide it for you. So the insurance board is working to institutionalize that a bit so that you can get some quick advice on some simple matters and help find a lawyer if you do not otherwise have one of your own. So I think the IB plans to roll that out pretty soon. I know they're still discussing getting the mechanics and of all that in place, but that'll be a resource that will be available to you if you have insurance from the insurance board.
Other questions for Andy around the subjects that we've been talking about? If not, thank you for your time this afternoon. Thank you for Andy for your presentation as well. You all have a great afternoon and blessings upon the ministries you do.